So while we're getting kind of set up, there's a further element to the anecdote, which was highly predictive, which is I had three RAs that semester, and one of them produced memos every week that were of value to the research, and the other two never really quite got it together to produce either the memos, or if the memos were produced directly, aided the research. And I'll figure out that you can guess which one it was that managed to figure out what the task was and delivered on a regular basis. And actually, I use this to talk to students about grades, which is there are lots of students who do really well at Columbia, but as you know, being a successful lawyer involves more than just having raw smarts. It involves actually getting the work done in a reliable way. And so I use this particular, is this not working?
No.
Okay.
I just want to put it back so that you get better photos.
Yeah. Oh, yeah. Okay. So anyway, and I use this this anecdote to tell students what really counts actually in the practice of law is being able to get the work done in a way that makes a difference, and the person who's counting on it knows it'll arrive. And we've spent a lot of time. I've been educated since by Igor on what's actually going on in the M&A world, and that's been a pleasure being a professor here over time. So in talking about antitrust in M&A, we really have an all-star panel, and I'll just say a few words about each and then ask them to speak for about 5 to 8 minutes, and then we'll have a discussion among the panelists and take questions from the audience. So our first speaker is Professor Lina, who before she came back to Columbia had a job at the Federal Trade Commission that maybe some of you have heard about, and really quite distinguished stint. And I've spoken to a lot of lawyers who disagree with some of the policies of the Federal Trade Commission, but there's been extraordinary praise for her, and in part it's reflected in the scholarship that she's done, which has been path-breaking and establishing paradigms and all of that. So our first speaker. Second speaker is Roger Alford, also a law professor, Notre Dame professor. Roger was in the Antitrust division of the first Trump years and returned to a senior position in the second Trump years and left after a short period of time. Some of you are probably familiar about this. In legal ethics terms, we will refer to this as a noisy withdrawal, and I suspect you'll be addressing that some. Third speaker is Christina, a partner at Wachtell, who does a lot of antitrust, who's a Columbia Law grad, and in a relatively short period of time has really established herself as really quite distinguished player in this area. And what's also important is that she's been a writer on antitrust issues, so you can read the views she's expressed with others at the firm in the Columbia, the Blue Sky blog, and it's pretty neat to see her perspective on these things relative to Professor Katz, for example. And next, Josh Soven, partner at Hastings. Josh previously served in leadership roles and trial counsel roles and in the Justice Department, the Antitrust Division, and at the Federal Trade Commission, and so has the advantage of experience in important areas of the government, and now is a private lawyer, and I think will reflect upon some of that. And finally, we have the great benefit of a current government official, Elinor Hoffmann, who's the chief of the Antitrust Bureau at the New York AG. And so I think we'll be hearing from her perspective on what it means to be in a state office, how it compares and contrasts to the federal role. And so I think this will be really illuminating. The goal is to educate us all, and then we'll have some further discussion and the opportunity, as I say, for your questions. So with that, Professor Kahn.
Great, thanks so much, Jeff. Good morning, everybody. It's so great to be here. Jeff had asked me to kick it off by sharing some general reflections on areas where we've seen continuity between the last administration and this administration in their posture vis-a-vis M&A, as well as some areas where we've seen significant ruptures. And so happy to share a few opening reflections on that. I recall very vividly, shortly after the election, a lot of predictions around what a sharp pivot we were going to see away from the Biden administration's posture on M&A. It was widely speculated that the new merger guidelines that we had issued at the end of 2023 would be rescinded within the first week, that other initiatives we had underway, including updating the Hart-Scott-Rodino form, would be discarded. And I think there was surprise in the opening months of the Trump administration to actually see significant continuity within the first few weeks of the new administration. Both the new head of the FTC and the head of the Antitrust Division announced they would be keeping the 2023 merger guidelines in place. And at that time I wondered, okay, is it just going to be keeping it in place but not really following them? And it's been interesting to see as the agencies have been filing complaints that those complaints really do track the new merger guidelines in terms of the frameworks that they're offering, how they're viewing the structural presumptions. By December, we had over a dozen courts, validate, acknowledge, recognize the validity of the 2023 merger guidelines. And so the fact that the new administration is continuing to use them, continuing to cite them, creates more opportunity for that type of codification. The update of the HSR form, this is something that was a little bit more nerdy, but extraordinarily significant in terms of what the day-to-day ramifications are for deal makers. The first time we saw a major upgrade to the filing form since the 1970s. It included all sorts of updates, including requiring parties to offer more narrative about what the deal rationale was, asking them to provide more information on labor markets, giving us more insight into what's happening with some of the private equity acquisitions, including insight into roll-ups. That too had been anticipated to be rolled back. There was a bit of a split opinion because that is one rule that we finalized on a bipartisan basis. It was voted 5-0 out of the commission. And so there was a split view about what would happen there. Not only have we seen the commission and the DOJ fail to rescind that, but they've actually continued to vigorously defend it. There's at least one lawsuit filed by the Chamber of Commerce challenging the new HSR form, and the FTC, by all accounts, has been vigorously defending it and plans to continue doing so. So those are some areas of continuity that we've seen. In terms of areas of changes, I think there are two specific ones, and then I'll share just some more big picture reflections on what that could mean. One is just a much, much greater appetite for consent decrees. One of the positions that the last administration had taken was that looking closely at the history of consents, at the history of remedies that the agencies had entered into, we had realized there had been a much higher failure rate than we thought enforcers should be comfortable with. Merger enforcement generally is a predictive exercise, and so can be quite difficult. but especially when you are, crafting remedies, be it behavioral remedies that are going to be extraordinarily difficult for the government to administer and oversee, or even structural remedies, when sometimes enforcers are asked to almost act as deal makers themselves, figuring out what combination of assets, if spun off to which third party, stand a real chance of continuing as a viable competitor. And so we had introduced a higher standard in terms of what our threshold was going to be for accepting remedies and understanding whether they were fully curing the competitive risks and harms we saw. The FTC did still continue to accept certain remedies, sign certain consent decrees, but definitely the standard was higher. We've seen a retreat there. There's greater comfort with not only structural remedies, but behavioral remedies, including in horizontal mergers, which was something that there had started to be a bipartisan shift away from. And then the other change is the resumption of early termination. This is something that had been signaled when we finalized the HSR form, with the understanding that because this form was going to be providing enforcers and our staff with much more probative information on day one, information that was going to give us more insight into what is the competitive significance of this deal, that would allow us to make quicker decisions, both in terms of which deals may require a more in-depth investigation, requiring a second request, or which deals did not pose any competitive issues such that early termination could be granted. And so that has resumed, though I've seen some analyses suggesting that the spigot has not kind of been turned on as forcefully as some folks expected. Early termination grants have not resumed to what they were pre-2021. I think big picture, the way I look at some of the trends are, there is a real question as to what degree the facts and the law really still matter and are really still the primary set of factors on which decisions about merger enforcement are being made. We're going to hear from Roger some pretty disturbing allegations about the rise of pay to play, the suggestion that what matters is less what the frontline attorneys are finding in terms of the factual and legal analysis, and more whether you're hiring the right lobbyists with the right sets of connections to the White House. The second thing is, as we see a White House that is exerting much more authority, much more control, much more decision-making power over agencies like the Justice Department and the FTC, I think we see that reflected even in the fact that who is leading these agencies is actually much less relevant. We saw over the last week one of the sitting commissioners vacate her role. There's now a possibility that somebody new would be appointed. Historically, this would lead to a lot of speculation. Who are they going to pick? What is that person's views? And all of that has subsided because, the leadership at the agency is not viewed as really being the key decision makers in the same way because of the more significant role the White House is playing. The other thing I would note is, there's the way I look at it is there are two paradigms of how to do merger enforcement. There's one paradigm that, yes, is much more comfortable with consent decrees, much more comfortable with remedies, and there can almost be a view that the role of the agency when enforcing the Clayton Act is not just to spot illegal deals, but actually to facilitate legal deals. And I view that as more of a regulatory mindset for how to do antitrust, just much greater comfort with extensive back and forth with the parties, sometimes working together to figure out which assets should be divested, which is the right buyer, as well as a greater comfort with remedies that are going to require pretty significant ongoing oversight by the government in a way that we usually associate more with regulators than with enforcers. And I'd contrast that with more of a law enforcement approach, which the last administration was very clear we were focused on. Our primary goal with merger enforcement was deterrence. We thought it was a problem when merging parties were proposing deals that were facially illegal and then expected the government to sit down with them to figure out how do we convert this illegal deal into a legal deal. We thought that was work that should be done up front. And that was reflected also in the fact that we were less interested in some of the merger remedies. It's been interesting to see that shift back to much more of a regulatory posture. And I think one potential downstream effect of that is now what's happening in the courts. We've seen for some time parties engage in litigating the fix, which means basically even after the government has sued on a transaction, the parties will then introduce a new remedy or a new type of offer that they're willing to put on the table. And so for the government, the ground kind of shifts under them in real time, and increasingly courts are saying, well, even if the original deal was problematic, it's incumbent on the government to basically sit and really digest this remedy and really push the parties to settle. We've seen that, recently the FTC lost its Surmodics case in the context of certain medical device, in the medical device industry. It also happened with the DOJ and one of their United acquisitions they were overseeing. And I do wonder whether one consequence of adopting more of a regulatory posture is that courts similarly are going to expect the agencies to have much greater appetite for consents. And so even when they're choosing to litigate, they're going to be handicapped by the fact that parties can introduce new offers, and there's going to be a greater expectation for them to take it rather than to say the deal as proposed was illegal, Your Honor, and that's why we're looking to stop it. So those are just some big picture reflections, and I know Roger's going to pick up on a few of these threads too.
Thank you. Roger.
Yes, thank you. So thanks for the opportunity to be here. I really appreciate it. So I have described the problem in the Aspen speech that I gave in the middle of August. And so I want to use this opportunity to sort of talk about what are the possible responses to the concerns about good governance, the concerns about the desire for the market to have clarity and certainty. The worst thing in the world for the market, I think, is just complete and total uncertainty. And I think there's been a lot of anxiety in the market about that uncertainty. It's also obviously in the interest of the government to have clarity and certainty. There is a presumption of regularity that applies to the government, and if you are not acting consistent with your own procedures or acting with honesty and in good faith, then the presumption of regularity might not apply to the government. And it's in the interest of the government that they enjoy that presumption. And so I think that I wanted to just suggest a few comments about what is being done or what could be done to try to provide reassurance that things are going to return or become more on the right track. And so one thing that I think would be incredibly helpful, and is being done to some extent, certainly it was being done when I was there, is to tell the parties and to tell the law firms that we want to deal with the lawyers on the merits, that we don't want you to circumvent the process and try to go above or around the normal line attorneys or the leadership of the Antitrust Division, because if you do that, then you're not really resolving cases on the merits, you're resolving cases based on your political connections. So I think now it's incumbent upon the Department of Justice at every level to sort of reassure people that going forward, we're going to be resolving cases on the merits with the law firms based on substance rather than on connections. Another thing that I think could be done and should be done is much greater transparency demanded by the FTC and by the DOJ about who is representing the parties. It's common when you take a meeting with one of the parties that you say who are the law firms that are representing you. And we should have a total and complete identification of all of the lawyers that are representing them, including ones that are not in the room. And a lot of people say, well, they don't need to disclose in their FAR forms that they're a lobbyist because they're an attorney. Well, then disclose that you're an attorney working for the parties. And so I think it would be much improved change if the FTC and the DOJ demanded all of the parties to disclose all of the lawyers and all the lobbyists that are working for a case. A third suggestion that I want to make is it would be much better if the government wants us to take a particular policy position, that they say so very publicly and very openly. I think, for example, the fact that the executive order on live entertainment has been published gives the Department of Justice and the FTC a lot more clarity about what the government really wants on live entertainment, and the ability of lobbyists to circumvent that policy position, I think, is much reduced. And it doesn't have to be an executive order. Even the tweet from a couple weeks ago on meat packers gives a very clear signal to the market, like, we're not going to settle this case. We want to really pursue this case. So I think much greater guidance on policy would be significant. Fourth, I think it's very important that government enforcers, if they see irregularities, speak out. I mean, obviously I chose to do that because I thought that there were major irregularities that demanded significant change. And so I took a risk and did that, knowing that there was a very strong likelihood that it would raise those alarm bells and that individuals would respond to those. And so I've been very, very encouraged that what I hoped would be a short-term aberration is leading to much greater scrutiny of what is happening. And that scrutiny and that transparency is making it much more difficult for the lobbyists to play the games that they were playing in the past. So those are all four things that I think are happening at the federal level. The other thing I can say that's happening that's very encouraging is you do not want to have a single point of political failure. And in order to do that, you need to make it harder for irregularities to lead to a global settlement. And what that means in practice is we want state AGs to be more involved more frequently, and we want private parties to be more involved more frequently, because what the parties before us really want is a global settlement, and they can't have that with a single point of political failure using their lobbyists if the state AGs are involved or if there's litigation involving private parties. So I think that is an encouraging development, and I want to say that that's something that I think should continue to a greater extent. And then on the judiciary side, I think it's very heartening what's happening in California with a review, a very hard, careful review of the HP Juniper merger. I think that's a very strong signal that what normally is a very light touch review of a merger settlement is going to be given a very strong review. You got to credit the state attorneys general, Colorado, New York, California, the others that were involved in that, to basically encourage the court to take a really hard review of that. I think that also is a very helpful development. And then another thing that hasn't been talked about very much, but I think is very important, is it's not in the interest of the law firms to have irregular process. They want regular process, resolving cases on the merits. And so I think it's incredibly important that the antitrust section of the ABA and that the law firms really begin to talk more openly about what is proper and improper behavior by law firms. And why is it that law firms are not standing up and saying, we don't bring politics into merger review, we don't bring politics into conduct cases. And right now, there's been a fairly tepid response from that. They're sort of like trying to suggest this is all a problem within the government rather than a problem within the law firms. And I think the law firms bear a lot of the responsibility for allowing this sort of behavior. And so I'm really hopeful that they will step up. And then the last thing I'll say to help correct this is much greater public and press, we're in the School of Journalism here, much greater public and press review of the process. I think that's one of the great things that's happened in the past few months is like lots and lots of reporting that has been going on to try to disclose bring light and transparency and bring this behavior out of the shadows. I think that's incredibly important. And some of the reporting that's been done has been very influential, I think, in raising concerns about some of the behavior. I do think more FOIA requests, and not FOIA requests just about specific individuals within government, but more FOIA requests about what specific lobbyists are meeting and who are they meeting with. We need more FOIA requests about the irregularities, and I think that that's something that I would encourage to happen. So there's a lot of other things I could say, but I think if we can just continue with those sorts of processes, then I think there will be at least some degree of correction, maybe reluctantly, but some degree of correction to some of the problems that led to the issues that arose in the summer of this past year. So I'll stop there.
Before we move on, I just want to say Roger's withdrawal from the government, you could style it as a whistleblower action, really. And what's heartening to many, I think, is people often say, oh, there's no point to being a whistleblower. It doesn't do anything for the actions in question, and it's not great for a career. But I think Roger's resignation and the public speaking he's done have actually really made a difference. And I think that's important as a model perhaps for others who may be faced in similar scenarios. I mean, I'll say, you know, speaking of both the two professors here, it's great to have a law school to go back to, right? Because you don't have to worry about the clients who, and the law firm's willingness to take account of that. But anyway, so that's a plug for the role of the Legal Academy in protecting a certain vision of making the government work. So anyway, all right, so Christina.
Thank you, Jeff, and thanks for having me. I don't know if this is on, but I can speak more loudly.
Maybe your mic a little closer up to your, just slide up the piece. I think it's on.
Is that on? Better?
Yeah.
Is that better off? I can just,
We can hear you.
All right, good.
I think everyone can hear me, and I'll just speak more loudly.
Yep.
Not a problem for me at all. So like I said, Jeff, thank you for having me. Jeff had asked me to come today to talk a little bit about how these changes and the change in the administration is experienced by practitioners. I think as Lina highlighted, the single most significant change of this administration as compared to the last administration is the philosophy around remedies and the openness and willingness to negotiate remedies in the context of a merger review as opposed to within litigation. The prior administration was very vocal that they preferred litigation over a negotiated settlement. The result of that was, in our view, from practitioners' view, either litigating the fix, meaning going to court. It also meant that there were off-the-book settlements. So parties settling matters that had antitrust issues, pulling their HSR filing and refiling with the fix. You know, using the law enforcement analogy, that's the equivalent of sort of turning a blind eye towards minor infractions as opposed to entering into a plea bargain with the hopes that sort of the more egregious violations won't happen because there will be deterrence. And we can all debate, you know, which is the better enforcement model, but that is sort of how I would describe the differences between the two.
For the recording.
Thank you. So I'm gonna, you know, you don't need to hear from me how that change has happened. So Chair Ferguson, in announcing the Synopsys ANSYS settlement, which was the first settlement under this administration by the FTC, stated a settlement may be the best way to protect competition in some cases for two reasons. First, settlement can temper the potentially over-inclusive effects of an injunction blocking an entire merger, i.e., there may be pro-competitive aspects of a merger that we want to go through to drive innovation in the economy, while allowing a piece of the transaction that is anti-competitive from not proceeding. And second, the settlement maximizes the Commission's finite enforcement resources. Antitrust litigation is expensive. It is also uncertain. It is for those reasons, I think, that there were often these settlements off the books, because as a matter of resources, the antitrust agencies could not bring every single matter to litigation, but they also were not willing to enter into these negotiated settlements. Similarly, Gail Slater has remarked, this was at a Capitol Forum panel earlier this year, that she was more of a proponent in remedies and merger cases, but her words, not mine. She also knows a quote unquote bullshit consent when she sees one. And Bill Renner, former Doug and colleague of Rogers, in announcing the DOJ's first settlement in this administration, stated, "We want to be transparent about our goals for merger settlements. They must be strong, robust, and provide great confidence in their ability to protect competition." So while we've seen a change in a willingness to enter into negotiated settlements, the standard is still a very high one, and fundamentally reflects a change in philosophy from one of being anti-M&A to one of being pro-enforcement, but not anti-M&A. And we've seen that in some recent settlements negotiated in the course of a merger review. So in addition to synopsis ANSYS, the FTC has negotiated remedies in the Alimentation Couche-Tard Giant Eagle transaction, which involved retail gas outlets. They very recently announced a settlement in the Valvoline merger. All of these settlements, including some at the DOJ, are structural remedies, meaning a full divestiture of a standalone business to someone in the industry, so to a strategic buyer, and with an upfront buyer, right? And so these are the classic qualities that people often attribute to robust, strong divestiture remedies. And so that is a very welcome change amongst, I think, practitioners and corporations looking to do M&A. What we have not seen change is the politicization of antitrust enforcement policy. It is not exclusive to this administration. It has been increasing, in my view, since I started my career. And we could all debate if it's a good thing, a bad thing. Is it just more accountable antitrust enforcement? Or is it sort of this derogatory view of politics shouldn't enter antitrust policy? We've seen this both in terms of enforcement priorities. So tech and healthcare remain in the spotlight, both under this administration, the prior administration. The prior administration took a lot of efforts to reinvigorate Section 8 enforcement around interlocking directorates, just around governance. So we saw the consents in the Chevron Hess deal and the Exxon Pioneer deal, where I'd say that the FTC used the HSR process to extract a remedy proposing non-traditional theories of harm, but this administration has done the same. Lina sort of mentioned the behavioral remedy in the Omnicom Interpublic transaction, and there it was a horizontal transaction or horizontal merger, and the consent was that Omnicom would not, either unilaterally or in a coordinated manner, boycott ad dollars based on speech. So it was around this concern around content moderation, which is something that this administration has been very concerned about. And I think what we haven't seen, and what we may be a little bit more concerned about, is the extent to which, well, we're starting to see increased sensitivity, increased focus on industries that are viewed as critical to US geopolitical primacy, trade primacy, and you wonder whether some of the things that Igor mentioned around the government wanting to take an interest in companies starts to bleed into antitrust policy. Is the consent, now we're going to give some equity to the US government? Again, not something that we've seen, but you can see a world in which the two policies start to intersect. And then the last thing I'll note is that we continue to see negotiated settlements in the course of litigation. So the prior administration did agree to settlements in a limited number of cases, and it was typically in the context of a litigation. So the Amgen Horizon transaction was settled in the course of litigation. The Assa Abloy Spectrum transaction was litigated in the course of litigation, and that was a litigate the fix situation. So I don't actually think that courts will necessarily view a willingness to enter into remedies as a reason to force parties who decide to litigate into a remedy. We've seen that, yes, in this administration, but I think we saw it in the prior administration as well.
Okay, so Josh.
Is this working, or should I use the mic?
I think your mic is working.
Great. Well, Jeff, thank you very much, and thanks to Columbia for inviting me to speak here. I can't say I disagree with anything that's been said, but I'm going to take a slightly different approach to it over a longer time horizon. So I've been doing this long enough that I literally worked for just about everybody. I've worked with just about everybody across, various ideological spectrums, different party labels, et cetera, and I've been greatly privileged to do it. My kind of thesis, stepping back as a practitioner and as a former enforcer, is while it is absolutely true that process has changed, doctrine has changed, technique has changed, rhetoric has changed. Actual outcomes, I'm not sure, have really changed all that much. And I say that as a feature, not a vice. Several levels below the waterline, there is staggering bipartisan and multi-ideological support for antitrust policy and competition policy, not just in the US, but around the world. Every time someone says, well, look, this is the end, it's about to be shut down, it never happens. It doesn't even get close to being happening. You know, this is football season, so I'll sort of borrow an analogy used by a former commissioner. The discipline is really played between the 40-yard lines, and in certain ways it's played between the 45-yard lines. So if you look at actual sort of numbers of second requests, numbers of consent decrees or resolutions, be they by formal consent decree, by fix it first, by litigation, et cetera, by numbers of enforcement actions, by what is actually the agencies are doing on the metrics, it's not a flat line, but it's remarkably consistent. You know, for the econometricians in the room, you'll be able to draw a pretty tight regression line over the next 25 to 30, over the past 25 to 30 years, and it'll look pretty good, which again, I think is a good thing. Bigger picture, I often refer to sort of antitrust policy as an iceberg, and Lina talked about this when she talked about deterrence. 90% of the good the policy does is what never happens in the first place, or stuff you don't hear about or read about it, but you think about the market as a whole. 2 weeks ago, for example, I told someone, a client called up and they said, what do you think about this? I said, it's probably not going to work. They said, yeah, that sounds right to us. We agree. We're moving on, et cetera, et cetera. That's a really positive event for the economy. That's what's supposed to happen. That allows a market to function in which competition is driving allocations of resources and government is not setting the price. That conversation occurs hundreds of times each day, if not more, around the world. So if you even move beyond, if you expand your data set to beyond what the agencies sort of do in public and look at actual market outcomes in terms of market structure, what does happen, what doesn't happen, et cetera, I think you'll see a fair amount of consistency. And I find it actually fairly straightforward to advise clients with a high degree of certainty about what's likely to happen and not going to happen, regardless of sort of who's up, who's down, who's at the top of the org chart and not. So that's the same, and I think that's a good thing. So what has changed a bit in terms of substance and process? Chair Khan is exactly right that the 2023 guidelines brought back an emphasis on structural analysis, on market shares, market concentration ratios, and the like. And that has changed the thinking a little bit. A little bit of context on that. It was often said that the agencies moved away from structural analysis in order to de-emphasize the ability to enforce cases or to dial it back with respect to the level of aggressiveness of enforcement. It's not actually the way I sort of think about it. The problem the agencies were facing, which led to the 2010 guidelines, is that they were losing cases because they couldn't prove a market in differentiated product markets and the like. So the 2010 guidelines were an attempt to say, well, look, let's not be so stuck to market definition. If we can prove the deal is anti-competitive, we win, and it really doesn't matter what's up with the market. It wasn't necessarily right or wrong, and completely agree that the 2023 guidelines are going in a different approach that are affecting practitioners. But again, I don't really think it's affecting the outcomes all that much. I think it's affecting the process. I think it's affecting how lawyers think about it and the like. Now, what has changed dramatically really is process. And while process sounds super boring, and how could that be interesting? And that's not really what drives headlines or speeches and the like. I cannot overemphasize enough how fact-specific this analysis is in terms of outcomes, how much it is an on-the-ground reality sport where women and men on both sides of the table work super hard every day to figure it out. And so what's changed with respect to that? The new HSR rules do matter a lot. They do, in terms of resource allocation. I'm not saying they're good or bad, but it is absolutely true that time to prepare the form and the cost to prepare the form is 2x to 3x up across the spectrum. If you talk to law firms with large HSR shops, they will tell you that. The glass half full possibility of that is it does require the companies to produce more documents more quickly, which offers the possibility of demonstrating to the agencies more proactively, look, there's really nothing here, you should not issue a second request, you should go on. Second requests are god-awful expensive, and they keep getting more expensive. They just do. That's not necessarily anyone's fault, it just is. The second request subpoena asks for an enormous amount of material. It requires an enormous amount of time to figure it out. Documents, text, emails, et cetera, are exploding exponentially. So that has now truly become a women, men, and materials logistical process that in many ways can almost subsume the substantive analysis. I do credit the agencies across party lines for trying to think hard about how to avoid it. And to seeing if we can get rid of or shut down an investigation before a second request is necessary. And as a result, I think a lot of the emphasis these days, which again doesn't really get reported on, is trying to work constructively with the agencies quickly and proactively to avoid that second request that is in no one's interest. Let me say a few comments about litigation, which of course gets the headlines, and then I'll sort of stop and look forward to your questions. Litigation, of course, is super prominent. That's where everyone's keeping score, everyone's watching. A couple of things. I think the agencies, to their credit, have gotten dramatically better at litigating cases. And that's from learning by doing, learning from success, learning from failure. Not that long ago, it was commonly accepted that you needed to hire a very prominent outside litigator to first chair a big ticket trial. The most famous example of that was David Boies litigating the Microsoft case. That is not done anymore, for the most part, across both Republican and Democratic administrations. And I think that reflects the agencies really thinking creatively and constructively about how to do it. And then last, there's an enormous amount of emphasis, of course, on who won and who lost, and what does that mean for antitrust enforcement. Again, if you look back over 25 years, they've won some cases, they've lost some cases, they've won cases in the last 6 months, they've lost cases in the last 6 months. It matters. It does sort of affect the equilibrium of how people view enforcement, but a far more pervasive influence on what is driving enforcement, driving counseling, driving business decisions with respect to M&A, is that high degree of consensus between the 40-yard lines that I really believe exists. Thanks.
Elinor.
So, Jeff, thank you very much for inviting me, and to Columbia for hosting this conference. Jeff asked me to talk a little bit about what we do in the states. What are the sources of our authority? Who are we? Who's in the office? A little bit about our current cases and investigations. I'm going to talk kind of high level about that. And of course, relationships with fellow enforcers and how that might have changed or not changed in the current administration. So let me start with who are we? Every state in the country, except for Pennsylvania, has an antitrust law, and we use them. Every state in the country has some sort of bureau, division, section in their AG's office that oversees consumer protection and or antitrust. In New York, and I'll talk a lot about New York because obviously I know New York best, we have 14 lawyers in our antitrust bureau. I've been with the bureau for 20 years. That number has not changed, although our work has grown exponentially. At the time I joined the bureau, we had typically 1 active case in litigation. For the last few years, we've had 8 or 9 or 7. Fortunately, we're expanding. We have lines. This is what happens in government. You get lines to expand. And we are expanding. We're hiring 4 additional lawyers, which is a significant percentage increase. Just by contrast, California has about 65 full-time lawyers and also 3 economists in that number and some paralegals. Maine has 1 who oversees both antitrust and consumer protection. So what the states do is we often pool resources. It could be 5 states, it could be 49 states to investigate and litigate matters. Kind of what our background is in New York, almost all of us have spent time in large law firms. I was a partner in one for 16 years before I joined the AG's office. So we have quite a depth of experience here in New York. And as one might imagine, states like New York, California, Florida, Illinois, Pennsylvania, Connecticut I'll mention, and DC have a real depth of experience and tend to be leaders in antitrust investigations and litigation. So what are the sources of our authority? And the takeaway point here is that we have very broad authority. And I think this is not recognized at the outset, perhaps by many. Our authority flows both from federal law and from state law. So federal law, Section 16 of the Clayton Act, gives us the power to seek injunctive relief as a person when we see a merger or conduct that is concerning. That, together with common law authority, the Georgia v. Pennsylvania Railroad case, gives us the authority to seek equitable relief and injunctive relief specifically under Section 16. We had to get a statute passed way back in 1976 to enable us to seek damages for natural persons under federal law. That became part of the Hart-Scott-Rodino Act, and it's 15 U.S.C. 15C. Now, under state law, New York has what's called the Donnelly Act. It's a Sherman's Section 1 analog. It enables us to seek injunctions and damages when we see conduct that is a restraint of trade that's implemented with some sort of an agreement. We have criminal authority under the Donnelly Act, and we don't need a referral. We can also seek all sorts of equitable relief, injunctions, penalties. Penalties is not equitable relief, it's legal relief, but we can seek injunctions and penalties. In New York, in addition, we have something called the executive law. Executive Law 6312 enables the Attorney General to seek relief for any persistent illegality or fraud that impacts New Yorkers or that took place in New York or that was furthered in New York. It's a very, very powerful statute, and we use it very frequently. Almost all of our cases are brought in federal court using Section 16 of the Clayton Act as a jurisdictional matter. We often file state law claims along with federal claims in federal court. So, current cases and investigations. Without going into great detail, there's been a lot of attention paid to the cases that we're involved in against Google, Amazon, Meta, but that's far from the whole of our portfolio. We will address anti-competitive conduct or conduct of concern wherever we see it, and that includes, of course, the tech markets. It includes ski mountains in central New York. I'll get back to that one. It includes real estate. We recently filed a case in the Eastern District of Virginia against Zillow and Redfin. It includes telecom. So we run the gamut. We're not siloed into one industry or another. And let me just talk briefly about relationships with fellow enforcers. Our relationships with both the DOJ and the FTC at the staff level for sure have been consistently strong and cooperative. We frequently litigate cases or investigate cases alongside the FTC and DOJ. Our conclusions or analyses are almost always 99% aligned. In rare cases, we do have differences of opinion, major differences of opinion that lead to different outcomes. Now, one example of this was the T-Mobile Sprint case back in 2019, where we and the DOJ investigated very closely together. We all reached the same conclusion, that the merger as originally conceived was a violation of the antitrust laws. Then the parties proposed a settlement. The Justice Department determined that settlement was adequate and it would restore the competition lost because of the merger. The states looked at the settlement, and led by New York and California, we determined that it would not restore the competition lost as a result of the merger. And we went to trial. We challenged that case in federal court. We did lose. Subjectively, I think we should have won. But we did lose. But I think Josh, who was on the other side, would agree that it was a hard-fought, well-tried case on both sides, and certainly one that was important. One of the most important parts of this was the day we filed the complaint, I remember saying to some of my colleagues, we just won, because we had demonstrated that the states alone could file a well-crafted, important complaint and challenge a merger that did, on its face, raise issues, and proceed and pursue that challenge in federal court. And that was important. I want to make one point here, which is that the power of the states has been there for a long, long time. These are not new statutes or new authorities. But the way we use that power, the way we exercise it, the way we use that in collaboration with each other, with the federal enforcement agencies, and often alone. For example, New York challenged conduct in the pharmaceutical industry back in 2014, a case called New York v. Activists. We challenged it New York alone against activists, which then became Allergan during the course of the trial. We won. It was affirmed by the Second Circuit, so we will proceed on our own where appropriate. And so that power, I think, has been exercised more vigorously, more publicly in the past 15 years than ever before. Certainly there's been a sea change since the time I started as a young associate at our firm, where our first trial was against 10 state AGs, and it was a total mismatch. That kind of mismatch does not exist anymore. We're here, we're present, and in my view, we can make a difference.
So I want to ask the panel sort of the question that perhaps is on many minds, which is about their reaction to the new verdict in the Meta case, in which the judge decided that even if Meta had monopolized social media way back when and raised questions about the acquisition of Instagram and maybe WhatsApp, the world is different today. And I thought I'd start with Professor Kahn to get her reaction to the case and what it says for the ability of successfully bringing a case in an area where the dynamism is so great.
Yeah, well, there's a lot that one could say about the Judge Boasberg opinion that came down earlier this week, and I know we're short on time, so I'll try to keep it pretty brief. First of all, it's worth noting just how outmatched the government is, outgunned the government is when bringing these types of cases in terms of sheer resources, and it was just a remarkable feat by the FTC trial team who really gave it their all, and I know this has been a disappointing week for them. This complaint was first filed in December 2020, so at the tail end of the first Trump administration. And there had been a decision leading up to the filing of that complaint to bring this as a monopolization case and exclusively as a monopolization case. So the theory was that Facebook's acquisition of both Instagram and WhatsApp had been an unlawful effort to maintain its monopoly power, especially as the market was shifting from desktop to mobile. Interestingly, the states had filed a parallel complaint that alleged not just Section 2 monopolization, but also Section 7. That these had actually been illegal acquisitions. Unfortunately, the state's complaint was ultimately not able to proceed, and so this monopolization case became the only vehicle. And so, of course, the threshold question became, does Facebook have a monopoly? And that's unfortunately where the agency foundered this week. The judge came out and said, as he was doing the market definition analysis, that the FTC had not defined the market properly, and even if Facebook had a monopoly, when this case was filed, by the time of today, the market had changed so significantly. The market was so much more dynamic that it was difficult to see how it could monopolize. I think there's a lot to think through about whether pursuing this as a monopolization case as opposed to a Section 7 case was the right call. The agency was in a difficult spot generally, given that alleging that these were illegal acquisitions would bring to the surface the question of, okay, well, why didn't you challenge them 10 years ago when they were initially proposed? That was just an uncomfortable position for the agency, given that a whole bunch of the evidence that had been available as part of this proceeding was available at that time. Contemporaneous documents showing that Zuckerberg was viewing these as defensive acquisitions, that he was pretty panicked about the possibility of Instagram in particular, displacing Facebook. I think there will be important questions to be asked about whether Judge Boasberg got it right. There's a whole bunch on the market definition front that I think departs from how other courts have engaged in the market definition exercise. There's some parallels between what happened in the Whole Foods case, where the lower court refused to kind of, be able to view narrower segments of customers as the basis for how to draw a certain market, and then that was changed on appeal. So it'll be interesting to see whether the FTC ultimately appeals here and challenges some of those market definition errors. More generally, I think it just underscores the importance of vigorous merger enforcement on the front end. Being able to block illegal mergers on the front end is so much more efficient for the government than waiting 10 years and all of the various challenges that will have been compounded. I will say that it was interesting to see Judge Boasberg note that the just time elapsed had meant the market had changed so much, because it's also true that antitrust trials take a long time. This complaint was first filed in 2020. And we didn't get a resolution until the tail end of 2025. There were various things within the court's discretion that accounted for when the trial was ultimately set. That has not always been the case. One of the DOJ's Google cases, the ad tech case, was filed more than 2 years after the Facebook case. It was filed in January 2023. We got a decision earlier this year. They filed it in EDVA, where you have more of a rocket docket dynamic. So I think there's a lot to reflect on, a lot to chew on, but underscores the importance of being especially vigilant on the front end when these deals are being proposed. We're seeing a lot of deal making happening in the AI context, some as traditional acquisitions, some as more strategic investments and partnerships. This administration has taken a very hands-off to oversight of AI. They've issued an executive order that effectively grants a certain form of amnesty. And so I really hope we're not going to see a repeat of some of the missed opportunities that led us here.
Let me ask one other point. I know you've got to go, and that is one of the hallmarks of of the last administration's antitrust concerns was focus on the labor effects of M&A. So, you know, the loss of bargaining power that might result, even if the consumer effects might not be as great. So do you think that that's an important element in the antitrust policy then, and will it persist, you think, going forward, or is that one of the things that'll change and has changed in this administration?
It's absolutely vital, and you can go back to the legislative history of the Sherman Act, the Clayton Act, concern about how market power and monopoly power would not just rip off consumers, but actually create worse conditions for workers was paramount in terms of legislators' concerns. And there were cases, through the last century, they were thinking about labor markets. There was a several-decade hiatus when it came to federal enforcers thinking about labor markets, and that interest, too, was initially revived in the first Trump administration. You had the Trump FTC, doing workshops on non-compete clauses and making statements around how they were interested in this. It was really the Biden administration where we saw complaints filed that alleged harm in labor markets at the FTC. Our complaint seeking to block the Kroger-Albertsons merger alleged not just that the deal would result in higher prices for shoppers, but that unionized grocery store workers would lose critical bargaining leverage that would undermine, their credibility when they threatened to strike and ultimately lead to worse conditions. And that theory was validated by the court as one that was available, though she noted that there's, a dearth of the tried and true economic methods that are offered when thinking about consumer harm just isn't as robust on the labor side, and she noted that as a gap, which I see as also a really important signal to the academic and research community for where more of this work needs to happen. The Justice Department also, when suing the Penguin Random House Simon & Schuster merger, alleged that the deal would not necessarily result in higher prices to buyers of books, but that it would result in worse conditions for best-selling authors. So in both of those cases, we saw concerns with the labor market or the producer side of the market. We haven't seen any complaints filed yet that in this administration that are similarly showing concern for labor markets. We've seen some statements from the FTC, maybe some task force that were created looking at labor market issues, but we've also seen a retreat on areas like non-competes in terms of defending the rule. So I think, on the rhetoric, we've seen that certainly continue, even how, the leadership of the Antitrust Division talks about the importance of antitrust. She very much talks about how competition is about, protecting the working man and woman and making sure they're not getting a bad deal in our economy. Whether that rhetoric is ultimately going to translate into agency action that is looking to protect labor markets, it's too early to tell.
Can I just comment on Facebook as well?
Yeah, sure.
So several thoughts on Facebook. One, I think it's a mistake to file giant antitrust cases in the DC circuit. I think that it's a lottery and you don't know what kind of judge you're going to get. The US government is a repeat player before those judges all the time, so the relationship and the psychology of interactions with the judge in DC is very, very different. I think it's far more likely to lead to success if you go file in a rocket docket where you don't risk the delay tactics that these companies engage in, where you lose 5 years, 6 years because of the delays. And so I think rocket dockets outside of DC are the way to go. Both the Google search case and the Facebook case were overcome by circumstances, by changes of events. But if the trial had been able to go faster in 2 or 3 years, then you would not have had that sort of change. And so I think that's the critical strategic mistake that the first Trump administration made in filing the case where it did. Then the other thing I would say is I think that the FTC deserves credit for bringing the case across the 3 administrations. I mean, there was a lot of movement to try to settle that case, and to their credit, they were able to successfully push back against political efforts to have that case settled. So despite the fact that it was a loss, I was very happy that it went all the way to litigation. Third, I do think what Lina said is correct, which is I think that the judge should be rightly criticized for not recognizing the possibility of 2 markets. Basically, there's a market for content graph type material, these videos that were all forced upon us through the algorithms to watch. And then there's the social graph market, right? And we all go to certain apps because of the relationship that we have with our friends and our family. And you tell me, like, do any of you go to TikTok or YouTube to see what's going on with your children? What are your children doing, and where did they take a hike today, and things like that? I just absolutely cannot believe that the judge did not realize that the market to watch what's going on with your friends and your family is a different market than the market of that content of those videos. And TikTok and YouTube are just not in that market at all. And so he should have probably found that the brown shoe, there were two separate markets, and arguably he could say there's not a monopoly in one of the markets, but undeniably there's a monopoly in the other market. And I think that was a critical mistake.
The other thing I'll just note quickly is, one of the things the FTC did was use not just indirect evidence of monopoly power, but also direct evidence, pointing to various actions that Facebook had taken over the last few years that showed it could basically make its products worse for customers without seeing significant defection. The agency pointed to higher ad loads, increasingly irrelevant ads. There was some really shocking evidence during the trial, including that Facebook had shown millions of children's accounts to people it had internally identified as groomers. Just questions about, what are the kind of precautions that Facebook is taking to be a good steward of its platform and prevent certain types of abuses. And it was interesting to see the judge really downplay some of that direct evidence, including the degradation. I think Roger put it nicely in terms of highlighting some of the market definition errors that I think there would be an opportunity to appeal if this administration chooses to do so.
Can I just add one thing? So the state's case was dismissed by Judge Boasberg on laches grounds. So it was a time bar, which applied to the states rather than the FTC. And that was the clear reason for dismissing the Section 7 case and in part our Section 2 claim. I think the Meta decision this week raised some very interesting questions. One, is it even effective to bring a case in this environment, given how long it takes against tech companies? I mean, clearly in Google search, where the DOJ and states challenged the monopolization of search by Google. In DC, the case was filed in 2020, actually a few months before Facebook, I think. Mm-hmm. And the trial, at the trial, there was no mention of OpenAI. It was just not a factor. We started hearing about ChatGPT towards the end of that trial, and it was just in the news and not part of the trial at all. By the time the remedies trial happened, which was last spring, it was a major factor. So we have to understand that tech markets change very, very rapidly, and yes, we can bring a case in the rocket docket, but I'm not sure even that's enough. And so is there something that we could do with our laws here? Is there something that we could do to speed up the process in the courts? These are, I think, issues raised by the Meta decision this week.
Jeff, really fast if we have a minute. I disagree with Roger on overthinking where you file. I think that more often than not, Article 3 judges are very hard to predict in how they come out. The agencies have won a lot of cases in DC that I think certain people thought they'd lose. With respect to the Meta case, and these are obviously my views, I'm pretty sure Meta is a client of somebody, and Paul Hastings, it both reveals the power and the limits of the discipline. The power of the discipline is, as Roger said, 3 administrations, aggressively and thoroughly and diligently pursued a case that I'm sure had significant decision impacts, not just within Meta, but in the market as a whole, as people were deciding business strategies. But it is a big ask for any judge, regardless of where they sit, to unwind something that occurred years ago. I think as a general matter, federal judges are quite willing to fine for the government when they have something in front of them that they feel with a high degree of confidence, yes, this is the issue, this is the problem. I'm not worried about causing more harm than good. But that sort of temporal gap, I think, would make virtually all Article 3 judges cautious about ruling for the government.
So anyway, there's obviously a lot more that might be said, and you haven't had a chance. But we're at the end of our time, so thank you very, very much for really illuminating these issues. And so we're going to take a break and actually resuming in about 10 minutes. But for those who want CLE, I gather you have to sign up on a panel-by-panel basis, so please attend to that. Anyway, so.